can give opportunity to her.
Yes, sure, ma'am.
Yeah. Coming to this, from yesterday we were listening to IPR, that is intellectual property rights. Let us know what exactly is IPR. You have heard about the property, right? You know what a property means. It is a physical wealth or any other thing which you can pass it on to generations, and you can give it to as a legal hire will be there for that. But here, intellectual property is the property that is intellectual. The name itself says that it is an intellectual creativity which is being recognized, and a legal right is being given to the invention in the field of science, art, literature, and industry. That is intellectual property right. See, there are many types of intellectual property rights in this. The major things are patents, trademarks, industrial designs, and geographical indications of source. Apart from this, you have copyright also. Regarding this, Mrs. Girija will be giving you in detail. Just I want to tell you how important to protect your intellectual property. As a scientist, as a researcher, as a student, or as a person, as an inventor, you need not be an educated person to protect your intellectual property. If you have invented something which is new, which is non-obvious, and which is having complete utility, and it is totally novelty should be there, then you can protect your intellectual property. What is the importance of IPR? Why we need to have an IPR? Because you want to protect your invention, and it can create revenue, it can generate revenue, and you will have a reward and recognition, and it can trigger new inventions by other people. For example, when you are talking about COVID, yesterday, Mr. Vivekanand Sagar was giving many examples. Many of you have participated very actively, and you are talking about the inventions with respect to COVID-19.
मम्मी कहते सबसे मोटरोला वाला हमारा तो आईफोन में
क्या हुआ? आवाज ही खत्म हो गई।
आईफोन का कवर ले लो।
अरे बाप रे, ऐसा है।
Please mute your audio. See, it can create jobs, new jobs in new industries, and it can create confidence to the consumer, and it can increase the reliability of the product. That's product or process, whatever is being IPR protected. That is the importance of IPR. See, if you don't protect your intellectual property, there is an every chance of everybody start doing it. You may have one invention, and that invention, you may not protect it. You just release it into the market. It may click, and you may start getting a lot of revenue. But many other competitors may further improvise it, and they might release it with better marketing skills, and better revenue generation will happen to them. At that time, you cannot say that I was the one who introduced this product for the first time to the market. They cannot copy it. They cannot do it if you have not protected your invention. That is the major thing which you need to, being a scientist or being a researcher, being an inventor, being a person who is with a lot of creativity and think about novel ideas and novel concepts. In protecting your intellectual property is very, very, very important. My slides are also not moving. I think this is the problem with Zoom itself.
Maybe, ma'am. Ma'am, are you there?
Yeah, I think a problem is there with Zoom itself. Okay, please be patient with us. This never happened. All our presentations used to go seamlessly. Indu, could you able to contact her?
I don't know her. She is not responding to either normal mobile, or.
Okay, I will continue with my talk. Okay.
She,
Anyway, this.
she joined 4:45 only, ma'am. I don't know what happened.
Okay. Okay. Again, these slides are not moving. I will just go to normal mode, not full screen mode. It is not doing normal mode. Sharing is also, it's not allowing. Some problem with. Who is this? Somebody started sharing the screen. You just stop. Don't allow anybody to share, Hindu. Who is this? Who I liked somebody? Please remove him. Remove him immediately. You should allow me screen sharing, Indu. Make me co-host. It is not going for the, it is going for the screen sharing normal way, but I don't know.
Ma'am, you can close the PPT, reopen it, and again share it.
That's what I'm doing. Yeah. Okay. To create interest in the participants, I just want to talk about certain classic examples where we just say that we had spent a lot of money and revoking these patents, and we really had very tough time. To tell you some interesting examples, do you know that the patents which are very interesting patents, simple ones? Can you give me one example of simple patent which you could able to very simple patent? I think there is some problem with the Zoom itself. The simplest patent, which it always amazes me, I feel very happy to see those patents are simplest ones are. Can anybody give me one example? Cat eyes. Cat eyes which are there on the road, you can see which indicates the central position of the roads, two small bulbs kind of things which will be blinking, that has been patented. And your jump clip is being patented. Your pin, which you use it to pin it to papers, that gund pin we call it as, that is also being patented. Like this, there are many important inventions which are very simple inventions, but they have been patented. See the importance of protection of the patent. I just would like to discuss about this classic case of biopiracy in neem. What do you mean by biopiracy? It has been like a patent which is not actually not, they are not eligible to secure the patent, but still it is being done. The patent for neem was granted by the European Patent Office to the United States Department of Agriculture and the chemical multinational W.R. Grace in 1995. Dr. Shiva, an International Federation of Organic Agriculture Movement under the Green Party in European Parliament, has opposed it. In 2000, the European Patent Office revoked the patent, but the victory was very, very short-lived because again they went for an appeal. What they said, the appeal was dismissed. Dr. Shiva said, again at the hearing, Dr. Shiva said, it was pure and simple piracy. The oil from neem has been used traditionally by farmers to prevent fungus from ages. It was neither a novel idea nor it was invented. It is a major victory that the appeal has been finally dismissed. To dismiss this, it is not all that easy. We simply keep quiet. We allow people to patent our turmeric, our neem, our geographical indicator like basmati, everything we do it. But finally, what we do, we try to challenge it. When you want to challenge it, you will have to spend more money than filing a patent. You know this? You need to have a documentary evidence. Without having a documentary evidence, either in the form of a written document or in the form of a movie or in the form of an image or in the form of a picture, you cannot challenge any patent. That's the thing of this. Because this, how I came to know about this, when I'm working in Dr. Reddy's as a scientist, at that time they have organized a 3-day workshop for all the scientists. Mr. Subbarao, who is involved in revoking of our turmeric patent and neem patent, was the speaker at that time. He was mentioning when the turmeric patent needed to be revoked, actually, we could not able to revoke so easily. He collected even stories from Chandamama, stories from all the books like children's stories, where the classic usage of traditional turmeric as a wound healer is being documented. He went to Janapada songs, folk songs, and they collected. There was a room full of literature which has been collected to revoke this turmeric case. This has been done by some Indians in that country. And in 1995, these two Indians at the University of Mississippi Medical Center was granted with US patent for the turmeric as a use as a wound healing. When these people filed, Indian government has filed CSIR to revoke this patent, stating that there is a prior art. What do you mean by the prior art? Prior art means it is already done by somebody else. It has been published. It may not be as a product, but it has been published in the literature that this has been used. That is called as prior art. Based on the grounds of prior art, they tried to revoke this patent, but they could not able to do it because the evidence of traditional knowledge, including ancient Sanskrit text and a paper published in 1953 in the Journal of Indian Medical Association, helped them to revoke this patent. It is revoked in 1997 after ascertaining that there was no novelty. He was mentioning that this patent, they said, when we said that this turmeric is used in our traditional wound healing, it has been published. Then they said, no, it is being used, not used along with a vehicle like a coconut oil, or it is directly not used. Something and all, they try to say, establish their novelty in this patent. A continuous hearing happened, and finally it has been revoked. Revoking a patent means it is neither to them nor to anybody. It is the public property. Anybody can use it. That's all. The victory is only that's all, that anybody can use it. It will not give you the uniqueness or the whole and sole monopoly or property to anybody, even after revoking the patent. That means you should be the first person to do it. Then you can get patents for your inventions and novelties. Another important thing is, which I wanted to tell you is, there is this geographical indicator. Recently, this geographical indicator, we could able to get this geographical indicator. What do you mean by geographical indicator? Even patents, I want to give you some more interesting examples. The patenting is so powerful and it can create a brand for you. For example, there are certain things which we forgot the original thing. One such thing is Xerox. Actually, Xerox is not, it is photocopy. The original thing is, you need to call it as a photocopy. But we go and everywhere, even in India, it is Xerox. They say that. Actually, it has been a trademark. Xerox is a trademark which has already been registered by somebody, but it became so popular that everybody starts photocopying machine as a Xerox machine. That's how it can replace the original identity of the utility. For example, another important thing is dalda. The vegetable vanaspati is called as dalda. Even you go to shop and you call it as give me dalda. But it is actually a trademark. It is not the original name of the dalda. It is vanaspati ghee. That is, it is oil, vegetable oil, but it is being called as dalda. People get used to it so quickly if it is being branded and utilized so well. And when you come to trademarks like say McDonald's, everywhere you can see that yum, even Coca-Cola, and even your Poppins. These are all trademarks. These can be copied, and the originality of the thing will be, you can very easily see when you go to bus stands or railway stations. You can see Poppins. One word, one letter will be changed. It will be, instead of O, it would have been given as PA, PA. But your eye will read it as Poppins and only you buy it. And that means you are not buying the original product, you are buying something else. In a similar way, even crackjack biscuits, you can see this kind of many things which are being left and right, been misused and pirated, and it is being given in the market. A person who is educated can see the difference between Poppins and Tappins, but the person who is not educated, he just sees the way it is being presented, like the colors and the way the letters have been given. They think that it is the original product and they buy. These are all the infringements which are happening across every day in, day out. And one more example which I want to tell you is the geographical indicators. When it comes to geographical indicators, basmati rice case is a case which is like a very unique case, which has been happened again in America. In late 1997, the American company Rice Tech Inc. was granted a patent by the US Patent Office to call this aromatic rice grown outside India as basmati. When they started doing this as basmati, actually, as soon as you say that basmati rice, you feel that fragrance of the rice. It is been one particular area in India is being given as a geographical indicator of basmati. When they filed that this is the thing, geographical indicator, and you cannot use it, then they called it as Kasmati, Texmati, because it is being used in Texas. But still, the concept of geographical indicator, and it has been, the patent rights have been rejected to that company. Apart from this, there are many problems whenever you want to have an invention. First thing what you do is you have an invention. Once you have an invention, you want to protect it. Either it may be a design, or it may be a trademark, or it may be a copyright. And this design is being given for the designs of the industrial designs and any equipment or any instrument or even mobile designing. This can be design patents. They can apply and they can take it. Copyright patent is the one which is being given for the like writings, poems, poetry, all these things. They can take the copyright. When they take the copyright, it is like patents are for 20 years from the date of filing of the patent. If it is a copyright, it is from the person's lifetime plus 60 years. That means if a copyright is being given to our Janaganamana, and it is whoever has written, I know all of you know about it, and it is been plus 60 years. Only in this case it has been extended, but generally it has not been extended for a longer period. But copyright is like this. When you are you want to take a copyright or you want to take a patent, if you want to establish that you are the first person to invent that, what you have to do is our director, R&D director at Sami Labs Limited, he told me how to do this. This is a tip which I'm going to tell you. I don't know whether it works or not, but he told me this, how to do this. When you write a poem or you write a you want to take a patent, you have to write the invention in detail and register post it with an acknowledgement to your own name and don't open it. There will be date, seal and everything on that particular thing, and you have to open it in the court of the law. That's what he mentioned. I don't know whether it works or not. If Girija madam is there online, she would have explained to you. I'm a very, very, very child in this patent thing, but I want to tell you what are the important patentable things and why you have to do patenting and how to go about this patenting. As soon as we say that you need to take a patent, many people think that it is very, very tough to take a patent and it is very, very difficult to get a patent granted. And many people they file the patent and they say that I have a patent. It doesn't mean that if you file a patent, you have a patent. It is not that. You need to file a patent. For example, when you file a patent, first you have to file in India. If you are an Indian citizen, you have to file in India. You have 4 patent offices like Chennai, Delhi, Bombay, and Calcutta. And in this south, we have to file a patent in Chennai office. There is a form, online form, you can download it. And the cost of filing a patent is very cheap. It is only 1,000 rupees. But if you have to go through an attorney, you have to pay the fees for the attorney. That might take you some cost. After that, if you have to search, like patent search, to have your prior art thing, that also will cost you. Generally, if you want to protect your patent across the countries globally, then you have to go through PCT. That is, within 1 year of your patenting, you can file for the international patents. You can select few countries or you can go for all other countries. For each country, there will be a fees and attorneys will be charging you to tell the process, to file the patent. And after that, this patent will be published and it is for the general public. It will be in the public domain. Anybody can challenge or anybody can say that this patent is not novel because of this reason. There is a documentary evidence here. All that you can do it. But generally, public will not do that. But many other industries who feel that they are competitors for their own patent, those people will definitely do it for their own products and processes. They will be doing this. Fight will be going on. Big pharma giants will always be fighting with each other to protect their IPR. But there are certain things which you cannot patent. What are those things? These are called as non-patentable inventions. Any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic treatments, or any other treatment of human beings cannot be patented. That is why the vaccine, COVID-19 vaccine, which has been released, cannot be patented. And plants and animals as a whole are part, which is if it is there already existing in the nature, you cannot say that this plant first I identified, so I can patent this plant. No, you cannot do it. But the process with which you can extract the plant components, and if it is novel, if nobody has explained that, the procedures can be patentable. A mathematical or business method or a computer program or algorithms are not inventions. No, discovery cannot be patented. Only inventions can be patented. Do you know the difference between discovery and invention? Yes or no? We could have made it interactive, but somebody joined this and they started doing unnecessary chat. So I think we disabled the chat option. If you can enable chat option, we can discuss or we can make it interactive. I'm sorry for this. This has not happened earlier in any one of our webinars. It used to go so seamlessly, so well. A mathematical or business method or a computer program are not inventions, they cannot be patentable. A literally dramatic, musical, or artistic work or any other aesthetic creation whatsoever, including cinematographic works and television products, they come under, some of the things come under copyright, not on the patenting. A mere scheme or rule or method of performing mental act or method of playing game cannot be patented. A presentation of information cannot be patented. Topography of integrated circuits cannot be patented. An invention which in effect a traditional knowledge, which is in an aggregation of duplication of a known properties of traditionally known component or components, cannot be patented. Okay, these are all non-patentable inventions. There are list is very big. You can go through that, and that's where your patent attorney will help you whether your invention is patentable or not. Now coming to let us know. Now we know that IPR is a one which is very, very important in the industry. And we used to have department of patent handling department in industry like Dr. Reddy's and Sami Labs, because they survive on these things. And this department will be just doing the filing the patents and getting the patents granted, all these things they used to do it. If you are interested in this, if you are very good in drafting and if you are creative, don't think that I have already chosen, I'm not a lawyer, I cannot do it. It is not so. You can be a patent attorney. You can take up this patent attorney position. Why? These IPR in careers are very exciting and rewarding. They are very, see, they charge per hour actually. They allow you to talk. You have to go and tell them that they will switch on the clock, and they see that if I spend 1 hour of time with you, you need to pay this much. International patent attorneys will charge based upon actually they don't give an hour, they'll give less than that. And it is in association with creativity and innovation. It will always be challenging and exciting. And it is in association with popular culture and cultural icons. So it is very, very interesting to have a career in IPR. It is hot and lot of demand and lot of international exposure with foreign clients, and they pay you very well. That is why careers in IPR is very, very exciting. But how to go ahead with careers in IPR? If you are interested in IPR, what you need to do? Do we need to pursue a law course again? Not exactly. There are many courses. I will tell you about these courses for 5 minutes. If anybody is interested, you can make a note of it. You have proficiency courses in IASC. In an Institute of Science, every year they allow, I did that course for 6 months program. It can be along with your degree, what you are doing now. It can be along with your degree, what you are doing now. And only weekly 3 classes or 2 classes in the evenings they will conduct. You need to go there. And if you go there at the end of 6 months, they will conduct you an exam and they'll give you a certificate. That I secured it. Apart from this, you have in Coursera, and there is another interesting program in National Law School. This is also an evening program, and you need not attend to the classes if you don't have time. But before the examinations, they conduct 3 or 4 brainstorming sessions. If you attend those courses, that is enough. There is a course called as IPR in Biotechnology. It is 1.5 year course. They charge you around 6,500 or so for this course, but it is very prestigious institutional national law school. It is not all that easy to clear it, but you can do it along with your masters. So it will definitely help you to become a patent attorney or to file your own patents or to get into an industry where you can become scientist in charge of patents. That you can always do it when you are doing your MSc. What you have to do is you need to learn some most in-demand IP skills and find opportunities to apply those skills. Actually, I have discussed with Dr. Padmavati, who is going to give her talk. She is not well. If she becomes okay, she is going to give a talk. She is a patent professor in IIT Kharagpur. She is my friend actually. When she is in Bangalore, she was working for Monsanto. At that time, when I want to do this proficiency course in IISc, I asked her, would you like to join me? She came along with me and we both did that course together. Now she's the dean IP law in IIT Kharagpur. See this. She's a biotechnologist. She did her PhD in biotechnology. She was a scientist in Monsanto who is working on rice research. She was working in biocurating division, and she is now in IIT Kharagpur as a professor in IP law department. That's how the careers are very, very rewarding, and everybody needs you. Every industry needs you. If you can improve your capabilities in doing filing a patent or helping the people to take up IP to protect their inventions in the form of either a copyright or a design or a patent. Learn how to network with and present your track record in convincing manner to potential employers. You have to really do this. Then only you can become a good scientist or a good researcher where you help your management to protect the IP of the firm. Okay, now I want to tell you one more important opportunity for you. It is DST Women Scientist C scheme. In this particular scheme, what they do is every year they advertise, you need to take an exam. If you are an MSc student, you can apply. But the only criteria here is only it is for women. It is for women. Here you need to take up that exam. Once you are selected, 1 month they give you a training in Delhi. Okay. Later, another 11 months, you will be posted in a company as an intern in the patent department so that you can learn all the things. And this course is completely stipend oriented course. Every month you will be getting a stipend, and this is earlier it was around 10,000 rupees. Now it would have been increased because all DST women scientists things have been increased from 10,000 to up to 55,000 per month they get, but it may not be 55 for this particular program, but definitely they would have increased the stipend for this program. It is a 12 months course which is being funded by Department of Science and Technology, New Delhi. You can find about this program also. Yesterday, Vivekanand Sagar was mentioning about the program which is being supported by state government in a similar way, like state government's DST, in a similar way that it will be 1 month training program with stipend. You can even approach Mr. Vivekanand Sagar to get into that kind of a thing, and they provide internship also. That's what he mentioned yesterday. With this, I would like to say sorry once again because we could not able to listen to Girija. It would have been very effective. She joined.
I will join, madam.
She joined.
I do not know what the glitch happened because I was presenting it continuously. Suddenly in the middle I stopped because some sound came. I didn't get any response from that side. Then I saw there are 4 or 5 missed calls from your institute. Okay. So I called. Then they said no. In the beginning itself, I got disconnected. So okay. I will start from the beginning, madam. No issue.
Yes. Yeah. Go ahead. Please go ahead. I will stop sharing. And please go ahead. Yes, I tried to plug that gap. I asked people to.
You have been doing a good job, madam. You have been doing a good job. Yeah.
I don't know. I am not that authority to talk my own.
You're the older of 3 patents, no, madam. You have been doing a good job. Yeah.
Yeah. Thank you. Yeah.
Yes, madam. Let me share it. If anything happens, please tell me so that I will see it. Yeah. I do not know. This is the first time it has happened for me.
Sure, ma'am. We'll let you know.
Yeah. Able to see, madam?
Yes, ma'am.
So shall I start it?
Yes, ma'am. You started the screen sharing.
If it stops anywhere, you give me a call, madam. I will respond to it because I have kept it in the silent mode. I thought some other people is calling, so I didn't pick it up. Yeah, I'll do that one. Yeah. So, very good evening to all. So I'll start with an overview of IPR and then move to the patenting procedure, industrial design registration, copyright process, and then we will have the effective question and answer section at the end. So let me start with an informal definition of what is intellectual property. It is used to describe the results of creative and innovative endeavors. We call it as intellectual because it is created by the intellect of the human mind. And we call it as property because, like the tangible property, this intangible property can also be owned, sold, leased, or transferred. So what are the ways of protecting IP? Innovative product process can be protected through patents. Brands can be registered under trademark. Literary, artistic, musical, or any creative work can be protected under copyrights. Creative designs and industrial designs, indication of origin and the GI, and any confidential information can be kept as a trade secret, and the plant variety can be registered under Protection of Plant Varieties and Farmers' Rights Act. A single product can be protected by many IP rights. I have just taken the example of a pen. See, the pen as a product can be protected through patent. The name of the pen can be registered under trademark. The composition of the ink, which you do not want to reveal to the others, you can keep it as a trade secret. The style of the writing can be protected under copyright, and the look and the feel of the pen can be protected under industrial designs. So the foremost IPR is the patent. So what is a patent? It's a document. So which it describes the invention. At the same time, it creates a legal situation in which the invention can be exploited only with the authorization of the patent owner. The next foremost IPR is trademark. So the trademark is a sign that distinguishes the goods or the services of one person from those of the others. So it can be a word or it can be a letter, number, shape of the good, color, sound, and smell. But smell is not protected in India. It is protected in US. And Yago Hodel is a very famous sound trademark, which is protected in India. There are 4 types of trademark: certification mark, service mark, collective mark, and trade dress. So certification mark is used to certify the goods. So I've given the example of ISO 9001, and service marks are used in services industries like airlines, banks, insurance, and collective marks are owned by organizations like Lions Club or Rotary, and trade dress generally refers to the total package of the goods, and the shape of the Coca-Cola bottle is the famous trade dress. The next IPR, important IPR, is trade secret. So any confidential business information that provides an enterprise with a competitive edge is defined as a trade secret. So I have given few examples: the famous Coca-Cola formula, data compilations, manuals, financial information. These can be kept as a trade secret. And trade secret, the important characteristic of trade secret is that it can be protected without registration for an unlimited period of time. The elements of trade secret: it should be independent and it should have an economic or commercial value. It should generally not be known to the others, and reasonable measures would have been taken by the holder to maintain secrecy in the form of non-disclosure agreements or any other confidentiality agreement. GA is the other important IPR. So GA is a sign used on the goods that have a specific geographical origin and possesses qualities, reputation, or characteristic that are essentially attributable to that place of origin. There are around 417 GIs have been registered in India. So I have taken one example from each direction of our country. See, there are 4 categories: agricultural, handicraft, foodstuffs, and manufacture. So Darjeeling tea is a GI product, Kullu shawls and Dharwad Peda, famous sweet of Karnataka, Nashik Valley wine. So these are all some of the GIs. Copyright. So what copyright does? The copyright protects the creative works, say, of the authors. It can be writer, artist, architect, photographers, directors, or music composers. What are the works that can be protected by copyright? It can be literary work, musical work, artistic work, maps, technical drawings, photographs, motion pictures, computer programs as such, and multimedia products. The main characteristic of copyright is that, see, you cannot protect your abstract ideas. Only the expression of the ideas, that to the original expression of the ideas is copyrightable. And that expression has to be done on the tangible forms. So it can be a paper or a canvas or a CD or a DVD, as the case may be. The copyright owner, he has the exclusive right to reproduce, adapt, translate, distribute, publicly communicate, and publicly perform. The related rights to copyrights are the performer's right and the broadcaster's right. So what is performer's right? See, if a TV channel wishes to broadcast a live telecast of a dance, they should get the permission from the dancer. Similarly, no person can make a visual or audio recording of a broadcast without the permission of the broadcaster. Industrial design. This is another important IPR. Industrial design protects the aesthetic designs that are applied to the article. So it can be a shape or a pattern or an ornamentation or any other artistic aspect. But the designs which have the functional value or the utility value is not protected under industrial design. For that, you have to go for patents. So I've given an example of a car. See, if the aesthetic shape of the car increases the fuel efficiency, then that design has functional value. So it cannot be protected under industrial designs. You have to go it for patents. PPVFR. So this PPVFR is a sui generis system, means a system which has evolved on its own, and it is specific to India. So it not only protects the plant varieties, also protects the rights of the plant breeders and farmers. So a variety which is registered in PPVFR will give an exclusive right to the breeder or his successor or his agent or licensee if it is commercialized to produce, sell, market, distribute, import or export the variety. The varieties which can be registered under PPVFR can be new variety or an extant variety or an EDV, the essentially derived variety. And the duration for protection for these registered varieties, for trees and vines, it is 18 years. And for extant and other crops, it is 15 years. So having seen the duration for the PPVFR varieties, you can see the term of protection for the very important IPRs. So the patent, the term of protection is 20 years. So this 20 years is from the first filing date of the application. After that, the patent comes to the public domain. But you have to pay the renewal fee for every year to keep it alive. And for trademark and GI, the term of protection is perpetual. But every 10 years, you have to pay the renewal fee to keep it alive. For copyright, the term of protection is life of the author plus 60 years. And there is no need for renewal. And design, the term of protection is 15 years. So initially, the protection will be granted for 10 years. So at the end of the 10th year, you have to apply for the next 5 years. This is the trend of filing applications, IPR applications in India over 5 years. And 1920 is the latest annual report published by the Patent Office. And you can see nearly 4.27 lakh applications have been filed in that year. And the trademark occupies the major share, followed by patents, then copyright, design, and GI. And there is 11% increase. And you can see there is a substantial increase over the 5 years. And I am very much interested for the waiting for the annual report 2021 and 21-22 to see how many applications have been filed during the COVID period. We'll move to the patenting procedure. Am I audible?
Yes, ma'am.
Yeah, thank you, ma'am.
Yes, ma'am.
I was almost finishing the patenting procedure. No issue.
Yes, ma'am.
So now we'll walk through a short introduction to the patents, and we'll see the very important aspect, patentable and non-patentable subject matter, and the contents of the patent specification, and how to file a patent. As I shared, what is a patent? So it's a legal document. It describes an invention. Same time, it creates a legal situation. So where the invention can be exploited only with the authorization of the patent owner. And patent protects the invention and grants exclusive right to the inventors for a limited period. As I said, it is only for 20 years from the date of filing of the first application. Why do I go for a patent? So to protect my invention, to enjoy the exclusive right, and to ensure commercial return. Is patent necessary? My answer will be a big yes, because to encourage research and development and to stimulate the capital investment leading to the growth of the economy and to also encourage establishment of new industries, patent is highly necessary. We'll move to the important aspect of what is patentable and what are not patentable. See, what can be patented? The invention first, it must be novel. Second, it should have an inventive step. Third, it should be capable of industrial application. And four, it should not fall under section 3 and 4 of the Indian Patent Act. What is novelty? Novelty is that your invention should not be in the public domain before filing the application. Means it should not be in the prior art. And again, your invention may be new, but you should not use it prior or you should not publish it prior to the filing of the application. So these are all the obstacles for granting patent. Even your own publication will be an obstacle for granting the patent. That will be cited as an document in the first examination report. So always we tell people like first file the provisional, then publish your article in the journal. So first file, then publish it. So this is the famous case law related to the novelty. So the interesting part of this case law is that they say that the invention was not itself new, its combination with other element of the system producing the advantageous result would be sufficient element of novelty. See, the crux of it is that, see, even the improvement over the existing product or the process is patentable. See, you need not have to get a very breakthrough invention. See, even a small improvement. So, but that should not be in the public domain. That is very important. Improvement over the existing product or process is also patentable. Inventive step. So the inventive step is that it should have adequate technical advancement and it should not be oblivious to the person skilled in that. So you have come with an invention in biotechnology, that the person skilled in biotechnology, that invention should not be or not patentable. See, this is the case law which is related to the inventive step, and they say that a mere workshop improvement is not patentable. So what do they mean by the workshop improvement? See, you while developing a new product or a process, see, the routine improvements will happen. See, these routine improvements are referred to as workshop improvements, and these are all not patentable. Industrial applications. Industrial application is nothing but the other synonym words is the utility or the usefulness. 99% of the invention will have utility or usefulness. So this will not be an obstacle for granting patent. So the case law related to the industrial application, they say that, see, the invention should have the usefulness or it should have the capability for industrial application. See, it can be for profit or not for profit. So profit is not a criteria to determine the industrial application. Having seen what can be patented, we can see what cannot be patented in India. See, as I said, section 3 and 4 of the Indian Patent Act have listed out what are not patentable. The first one, they say it's a frivolous invention or the invention which is contrary to the well-established natural laws. So I have given some basic example for frivolous and also for the contrary to natural law. So frivolous is just merely making in one piece the article previously existing in 2 or more pieces. And perpetual machine, this is contrary to the law of physics. So these are all not patentable in India. And second, the inventions which are contrary to the public order or the morality. See, supposing I come with a gambling machine or the device for breaking the house or a biological warfare material, these are all contrary to the public order or the morality. So these are all not patentable in India. And third, a mere discovery of a scientific principle or a formulation of an abstract theory or a discovery of any living or non-living substances occurring in the nature. So discovery of microorganism, it is not patentable. And any scientific principle like Newton's law or Einstein's theory, these are all not patentable. Then discovery of a new form or a new property or a new use of a known process or a machine or an apparatus, these are all not patentable. See, for example, a crystalline form of a known substance. See, already the substance exists in the amorphous. You say that, no, I have come with a new form, crystalline form, I want to go for a patent. So this objection, this is section 3D. So this will become an objection and you will not be granted patent. And again, a new use of a substance. See, for example, aspirin is well known for headache. Suppose you say, I have come with a new use of it for heart ailment. Again, it is not patentable. Substance obtained by mere admixture. See, this is a main objection for patents related to composition. See, whenever you come with a composition, see, if I say that I have developed a drug by mixing two drugs, say they say, no, it's only an admixture. So what we have to give in the specification is that we have to give the synergistic effect. So what is synergistic effect is that the interaction between the components. See, for example, I have to say only when there is paracetamol, what is the effect? When only there is Brufen, what is it? See, when I add both, there should be an increase in the efficacy of the drug. See, that I should prove it. If I prove that one, then this objection will not be there. And this is a main objection for the invention related to the composition. And mere arrangement or rearrangement or duplication of known devices, each functioning independently. See, suppose I come a clock and radio in a single cabinet or an umbrella with a fan, these are all not patentable. A method of agriculture or horticulture is not patentable. A cultivation of mushroom or an algae, or you prepare an improved soil using nematodes, these are all not patentable. A method of treatment of human being or the animals to render them free of disease or to increase their economic value. See, a method of performing art surgery is not patentable, but if you come with a cosmetic surgery, then it is patentable. Plants and animals are not patentable in India. So it is patentable in US. In US, you have 3 types of patent. You have utility patent, design patent, and plant patents. So in India, plants and animals, essential biological process, seeds, varieties, these are all not patentable. They are plants are protected under PPVFR, varieties are protected under PPVFR. And again, microorganism is an exception. That too not just a discovery of a microorganism. It should be a genetically modified microorganism. The mathematical methods, business methods, computer program as such, or an algorithm, these are all not patentable. So I say that a computer program is not patentable, but if it is embedded in an hardware and it produces a technical effect, then it is patentable. Literary, dramatic, musical work, or any creative works, they are all under copyrights. A method of performing mental act or method of playing games, these are all not patentable. A presentation of information is also not patentable. Traditional knowledge. See, this is like if I say that the turmeric heal wounds, they say it is traditionally known, so it is not patentable. But if I come with an ointment which comprises turmeric along with other excipients, then it is patentable. Invention relating to atomic energy. This comes under the section 4 of the Indian Patent Act. So any invention which falls within the section 21 of the Atomic Energy Act 1962 is not patentable. So this is the crux of what I have been describing. See, this is a famous filter model developed by Dr. Kalyan of Banana IP. See, you have the invention at the top. See, if you want to get the patent in hand, it should pass through these 5 filters. The first filter is that subject matter. So first I said it should not fall under 3 and 4 of the Indian Patent Act. It should be a patentable subject matter. Second is the usefulness or the utility. Third, novelty. Novelty is prior use and prior publication. These are all the obstacles, or they determine the novelty of your application. And non-obviousness or inventive steps. See, there should be a technical advancement in your invention over the prior arts invention. And then specification. Specification, this is the techno-legal document which the patent attorneys drafts and we submit to the patent office. So it should be drafted in a best mode, explaining with working examples. So now let me explain about the specification. As I said, it's a techno-legal document. The scientific details of the inventions are mentioned in the specification. So generally we call this patenting act as a quid pro quo, means the inventors, they disclose the invention to the government. So in turn, they get the right granted by the government for 20 years. And specification, there are two types of specification. The one is the provisional, the other is the complete. So what is provisional specification? So provisional specification, it is generally filed when your invention is at the conceptual stage. See, you know that this as a patent, you can go for a patent, but you need time to develop the invention. And so that stage, you can go for a provisional, because once you file the provisional, you will get the priority date, that is a first filing date, that determines the novelty of your invention. So when you feel that you need time to develop your invention, you can go for provisional, because once you file provisional, you have 12 months time to file the complete specification. So that period can be utilized to develop your invention and then file the complete specification. But if you file provisional and you don't file complete, then patent will not be granted based on the provisional specification. And complete specification is the one in which all the details of the invention should be disclosed. If you have the invention complete in the first instant itself, then you can go directly for the complete specification also. It's not that you have to follow provisional complete. If it is a conceptual stage, you go for provisional complete. If the invention is complete in the first instant itself, you can go directly to complete specification. The patent has 3 sections. The first is, so the cover page, it presents the claims, defines the scope of the invention. So this is a cover page of a patent. So this has its application number, date of filing, the title, the name of the applicant, the name of the inventor, and a short abstract. Contents of specification. So the specification has the following information. So it has the title, field of invention, background of the invention. So you have to cite it. What are all the inventions available in the prior art and how your invention is different from that invention. And clearly state the objectives of your invention, a short summary. And if your invention has drawings, you have to briefly describe it and also attach the drawing sheets. Then you have to describe the invention in a detailed manner. That is very important. You have to describe the invention in the best mode with working examples, and it should accompany with a short abstract. Claims, as I said, claims are the most critical part. So whenever your invention is infringed by the other people, we look only to the claims of the specification very carefully, and what is not claimed stands disclaimed, and we call it as an art and a science, because a claim language is different. Like a single claim, it should be in a single sentence. So it can even be a page. So that should not be a full stop in the middle. So you have to draft it in a single sentence. So we call it as an art and also as a science. We'll see how to file a patent. So who can apply for a patent? A true and the first inventor. In cases where the inventor has assigned it to some other person, the assignee can also file. And if the inventor or the assignee is deceased, then the legal representatives can file it. Where to file? In one of the patent office based on the territorial jurisdiction of the place of the office or residence of the applicant or the agent. And there are 4 patent offices, one in Chennai, Mumbai, Delhi, and Kolkata. We, the southern states, have to file in Chennai, western in Mumbai, and northern in New Delhi, and the rest of the states in Kolkata. How to file? Through online, through post. This hand submission has been taken away due to COVID, and more than 90%, even 95%, they file it through online. In rare cases, they do accept it through post. This is a general procedure for obtaining a patent. First, file a patent application, wait for 18 months to get it published in the patent official journal. Then there can be a pre-grant opposition, which can be filed by any person. And once you have filed RFE, the request for examination, your application will be examined and the patent may be granted or refused. And once it is granted, it will be again published in the patent office journal. And there can be a post-grant opposition that has to be done within 12 months from the grant of the patent. and the controller's decision is final, whether to revoke it or proceed with the grant of the patent. The basic documents which we have to submit for filing a patent application, the form 1, which we call it as an application form, that should be accompanied either by provisional or complete. And we should also give an undertaking that, see, suppose you have filed in India and subsequently you file in other foreign countries, we have to inform the patent office regarding that filing, and the declaration by the inventors is also very much essential. Along with that, you have to pay the required official fee. So this is the fee structure. You can see that the educational institution, it was in others, it has been moved to this category in last September. So there is a reduction of 80% fee for educational institution. So earlier you have to pay 8,000, and if you file for RFE, you have to pay 20,000. So 28,000, now it has come to 5,600. So there is an 80% reduction in fee to encourage educational institutions to file more patents. And so, and this is for 30 pages of specification and 10 claims. And if you go for addition, in addition to the 30 pages and or in addition to 10 claims, you have to pay this extra fee. So I have shared some of the granted patents in India in the domain of life science. And since I came to know that I will be addressing PGs and faculties of food and nutrition, biotech and microbiology, I have just taken some few examples. So if you see in food and nutrition, a bakery food product has been given a patent. A coated legume-based food products, means these are all the products as such, they have given a patent. And if you have developed some device or implement, see, for example, a grater for grating food items, a food spoilage reduction device has been granted a patent. And again, a nutraceutical formulation for metabolic disorders. This will also be, I've just taken one example. There are many patents that have been granted in the domain of food and nutrition. And again, if you see biotechnology, you will have enormous patents. And if you see a method, a PCR-based detection method for coronavirus, COVID-19 infection, they have a patent has been granted. A method of detection of DNA transformation using carbon dots, and also for isolation of rare endophytes from a host plant. So these are some of the examples in the field of biotechnology. And if you take microbiology, again, if an improved composition medium for the assay of a probiotic organism, a patent has been granted. This patent this belongs to Madras University, and I have worked for that in the prosecution stage to get it granted. And an improved medium composition and process for enhanced lutein production for microalgae. So these are all the patents related to microbiology. So there are some few examples I just want to highlight. So I have taken. We'll move to the next important part, that is industrial design registration. As I said, design means it may be a shape, or it can be a configuration. Configuration is that arrangement of the parts, or it can be a pattern, or it can be an ornamentation, or a composition of the lines or the colors applied to any article that produced by industrial process. And one more element of the design is that it should appeal to, and it is judged solely by the eye. So what are the requirements for design registration? As I said, for patent, it should be novel. Just 1 minute. As I said, for patent, it should be novel, inventive, and industrial application. Here also, there are some requirements for design registration. The first is that it should be original. So it should not have been a copied one. And second is that it should not have been disclosed in the public, and it should be distinct. That what we say, it should be distinguishable from the known designs, and it should be applied to an article, and it should not contain any scandalous or the obscene matter, and it should not be contrary to the public order or the morality, and it should not be prejudicial to the security of the India. So these are all the essential requirements for registration. What are excluded from the scope of the design? A book, calendar, greeting card, map, label, any scientific principle or the mode of construction of an article, architects, buildings and structures, part of the articles, variations commonly used in the trade, a workshop alteration, change in size. A change in shape of the article is protected under industrial design, but merely changing in size, that is not protected under industrial design. flags, emblems, signs, layout designs of IC. This you have a separate act, Semiconductor Act. So this is not protected under industrial designs. Again, patent, who can apply for registration, for design registration? Any person, or a legal representative, or their assignee. So person can be an individual or a firm or a partnership or a small entity or a body, corporate or an educational institution. So 10 steps you can get a design registered. So the first one is that you should see whether any registration already exists. So this can be done by searching in the unpaid databases or paid databases, or even you can write to the design office and ask them whether the same design is already registered. Then you have to prepare the representation of the design. So that design is that you should prepare the different views, perspective view, front view, top view of your design. Then you should identify the class of the design. See, there are around 32 classes in the Locarno classification. See, for example, I come with a design of a foodstuff, then the class is 1. See, suppose I come with a package of the foodstuff, then it comes under 9. So if I come with some lab equipment, for example, an incubator for microbiology, so then that comes under the 24. Or I come with a new design of a microscope, so that comes under class, I think, optical classes. Let me see it as, I don't know, I just forgot that one. So that class, so you have to just specify the class for which it comes. Then you have to provide a statement of novelty. So what is that? You should say where the novelty lies, whether it is in the shape, or whether it is in the pattern, or whether it is in the ornamentation. So you have to state that novelty, and you should provide a disclaimer if that design has some trademark or some construction principle. And the priority date claiming is normally done when they file in foreign country and then they come and file in India. Priority date is the first filing date that they can claim. And what is the fee to be paid? So in this case, it is 1,000 for individuals and 4,000 for others. And see that all the enclosures are attached properly, and complying with objections is that once you send the application, immediately they will do the formal examination and they will write to us through mail. So if you provide full details and then comply the objections promptly, you can even get the design registered in 1 or 2 months. Where to file? So you can file in any 4 patent office, but the prosecution for design is always done by the Patent Office, Kolkata. What are the benefits of design registration? See, the design, once you register the design, you will have the exclusive right for it. And again, in the case of infringement, this is the document which is produced before the court. And when in case of commercialization of your design, see, whether you license it or whether you assign it, then this is a document used for claiming the damages, and also it's a legal property for consideration for royalty. As I said, the official fee, it is 1,000 for individuals or startup or small enterprise, and for others it is 4,000. Again, I have taken examples for industrial design to show in the field of food or microbiology or biotechnology. You can see that there are many foodstuffs designs. See, this is some chocolate biscuit sandwich. They have got that design registered. And again, this is a food package for a beverage or food. And somebody has come with a pizza cutter, a new design. So these are all registered in the foodstuff category. And many microbes have been, new designs of the microbes have been registered. And this is one biosensor based biotech device to detect the lung cancer. And this is a portable incubator for microbiology. So these are also a few examples which have been registered under the Industrial Designs Act in the field of food and nutrition or microbiology or biotechnology. And also, if you have some designs of trash containers, or you have come with a new design of a composter, so these are also eligible for industrial design registration. And finally, even the COVID accessories have also found a place. So many designs of masks or oximeter or the sanitizer dispensers have been registered. And we move to the final section, the copyright process. See, how copyright is going to benefit the life science domain is that, see, you can get a copyright for your book or for an scientific article. Apart from that, the bioinformatics, which is part and parcel of the biotechnology, if you have come with a biological software or a biological database, they are eligible for copyright protection. So copyright as patents is for intellect, copyright is for creative works. And what are the characteristics of copyright? The first is it's a creation of statutes. It's not a common law, right? Like a trade secret. So this is created by under the Copyright Act 1957, and the copyright has multiple rights. As I said, right to reproduce, right to translate, right to publicly communicate. So there are multiple rights. The main characteristic of copyright is that it should be original. See, we always put in quotes, original expression. That is important for copyright. And abstract ideas are not copyrightable. What types of works can be protected by copyright? Literary, dramatic, musical, artistic, photos, cinematographic films, and sound recordings. What cannot be copyrighted in India? So it can be an idea, method and systems, the scientific technical methods of discoveries, business operations, procedures, mathematical formulae, principles. These are all not copyrighted. So how to register go for a copyright? So just visit copyright.gov.in and sign into that. This copyright registration form will be there. So you have to fill it in 4 steps. So first we have to fill form 14. Then you should upload the scanned signature of the applicant. Then fill up the statement of particulars. Then fill the statement of further particulars. Then move to the payment. So once you this is a simple process. So then once you file it, you will be given a diary number. See, normally in trademark or patent or industrial, we say application number. So in copyright, they call it as a diary number. So you will get the diary number, and you should also upload a soft copy of few documents which you have to do, and also send the hard copies to the Copyright Office. And this is the official fee for copyright. If you file a literary or dramatic or a computer program, this is 500 per work. And if it is for a cinema film or a sound recording, it is 5,000 and 2,000 respectively. What are the advantages of copyright registration? As I said, for design, same thing. See, you get an exclusive right, that is a proof of ownership. And in case of infringement, this is an important document produced in the court of law. And again, whenever you want to commercialize it, see, this is this document is very much essentially, and especially if you want to claim any damages. And this is the workflow of copyright registration. As I said, file it, you will get the diary number. Then there is a 30 days mandatory period. See, they will keep your application for 30 days. So to receive any objections. See, if there are no objections, then it will be scrutinized. And if there is no discrepancy, then it will be registered. See, we got in the last 1 year, many copyrights, around 5 or 6 copyrights. And even one copyright, we got it in a record time of 47 days, I think. Yeah. We got it in record time. So if there is no objection and no discrepancy, directly your copyright will be registered. And if there are objections, then both the parties will be heard. And if there are discrepancies, you have to reply to them, to the registrar. And once it goes through those hurdles, then you will get the copyright registered. So let me wind up this session, leaving this thought to you. And thank you all for patiently listening to my presentation.
Thank you so much, ma'am,
Thank you.
for delivering a powerful talk. Now the session is open for open discussion. If you have any queries, you can text it in text box. Then I'll read it for you people. Any questions?
Yeah, thank you, Mrs. Girija. It was an excellent session.
Thank you. Thank you for giving this opportunity. Thank you.
Actually, there are many budding entrepreneurs and also inventors in our team. we are planning to have a IP cell in our institution.
Yes, ma'am.
I'll send an invite. I want you to be the advisory member in that IP cell so that you can guide our students and you can help them out to take the patents. I myself has got 2 or 3 which I'm planning to discuss with you for a longer time. We
Yes,
will see
ma'am.
that what we can
Sure,
do.
ma'am. We will take it forward, madam. Sure,
Yeah,
we'll do it. Yeah.
Yeah.
Yes, madam. Yes.
Question session is open for sessions. Questions, please. Type your questions.
Any questions related to this session, please? If it is there, you can just text it in text box. Ma'am, there is a question to you, ma'am.
Yeah.
Can
yeah,
I
madam.
take a copyright for my ebook?
Yeah, surely you can take it. You can do it. And there is also one more question, like if someone copyright our work, how action will be taken? That's what, see, copyright is that when you develop a work, it is copyrighted on its own. So unless you register it, you cannot take action. That's what I was telling under the advantages of copyright registration. So if this is called infringement, see, when infringement happens, you have to, your work has to be registered under copyright. So if it is not registered, you cannot take action. That is the enforcement action can be taken only if your work is registered under Copyright Act. I think I have answered to the question.
Yes, ma'am. Thank you, ma'am.
Yeah.
Any queries? Yeah, one more is there, ma'am. If someone copyright our work, how action will be taken?
Yeah, that I answered for that question also. I said,
Yes.
like if it has to be registered. If it is registered, you can take action on them. That is called enforcement. See, first we normally write to them saying that you have copyrighted, we will be taking action. In spite they proceed, then we have to claim damages from them. Financial damages from them. Yeah.
Can a food science student pursue a career in IP law?
Sure, madam, they can do it. As I said, now there are many patents in the area of food and nutrition. I have just cited few patents. Now, say in food science and nutrition, not only for the product or the process, but also if they develop some device or implement also, that is also patentable. So they have good scope also.
Thank you, ma'am. Any other question? For provisional patent, is it important to have a whole report, madam?
No, not necessary. Not necessary. If it is in the conceptual stage, that see, we don't draft claims for provisional application. So the details of the invention may not be given, but the crux of the invention we have to disclose in the provisional specification. And then we can take that 12 months time to develop our invention, and then followed by that, we have to file the complete specification.
Yes, ma'am. And there's one more question, ma'am.
Yes.
Can you please tell us what is meant by discrepancy in copyright?
Discrepancy in copyright, which in relation to what? So normally discrepancy means it's against it. Na? So discrepancy of what? There should be some important matter of that in copyright. Discrepancy of something. What is that something they want? If I know, I can tell on that. In relation to what discrepancy?
She has not mentioned it, ma'am.
Okay.
Yeah.
Yeah.
For the benefit of the participants, if anybody wants to directly contact Mrs. Girija for filing a patent or taking any assistance, with your permission, You can give your email ID or your mobile number, maybe email ID you can give to them so
Yes,
that
ma'am.
they can contact you.
Yeah. I'm just sharing, madam.
Yeah.
Any other queries? There's one more question, ma'am.
Yes, ma'am. Yeah.
In patenting, will the guide and researcher both will be owner equally?
Yeah. See, in patent, there are two columns. One is the applicant. The second is the inventor. Okay, see, if you develop an invention during as a professor or in the college, then the applicant only will be the college, because you have used the resources of the college, and you would have even signed in your employee contract that all the IPs which you have developed during your tenure as a professor in the college, the IP rights goes to the college. So applicant will be the college. So inventors, you can have n number of inventors. It will include guide and also the students.
Yes, ma'am. Any other queries, participants?
Mrs. Girisha, I have one query.
Yes,
For
ma'am.
example, we have a patent. You know that I have a patent in biofortification, that is
Yes, ma'am.
improvised.
Yes, ma'am. Yes, ma'am.
The same thing, if I utilize one of the component will be my biofortified product,
Okay.
and there will be other components.
Okay.
And if I make a feed or a food, can it be patented as a formulation?
No, you're telling on the basis of the granted patent, madam.
Yeah, granted patent.
Yeah.
I have a granted patent. In
Yeah,
that, I have, say, for example, I have increased iron in one particular thing.
Right.
Naturally. And
Yes.
this will be one of the component of other products. For example, I'll make a biscuit out of it.
Okay.
In this iron rich atta, wheat will be one component. Apart from that, I use other nutraceuticals and do something. And if I do a product out of it, can it be
That's what
patented?
we normally call it as improvement over the existing patent. See, suppose we come with an improvement or a modification of your granted patent, or which is in the published stage also, then you can go for patent of addition, madam.
But is there any time limit for that? Before this time you have to go?
No, madam. Granted patent, the main patent of addition is that the applicant should be the same. That is the main criteria. And as long as that we call it as a parent patent. So as long as the parent patent is live, you can go for patent of addition.
Okay. On this basis, I want to go ahead with many things. I will discuss definitely in this week only.
Sure.
We can go ahead with this some of these improvised versions of it.
Sure, madam. We'll do that one. We'll do that one.
Thank you, ma'am.
Yeah.
Thank you, Girija ma'am, for delivering a powerful talk and giving us an overview of patent design, trademark, and copyright. On behalf of our college, I extend a gratitude to you, ma'am, for accepting our invitation and delivering a powerful talk.
Pleasure.
And I also, thank you, ma'am.
Yeah.
I also thank our dear principal, ma'am, for her immediate response to the inconvenience raised. Thank you so much, ma'am, for delivering a powerful talk in the first session. And I also thank all the participants who made this session successful. Tomorrow, as the nation is going to celebrate 72nd Republic Day, there won't be any sessions on IPR. We shall meet you all on 27th of January, and thank you one and all. On 27th, we have 2 sessions. Morning session will be taken by Nandini ma'am. Her topic will be traditional knowledge to geographic indications and registrations. And evening session will be covered by Padmavati ma'am. Her topic will be patentable and non-patentable inventions. So please note this change and note this schedule for 27th.
Thank you. Thank
Yes,
you,
ma'am.
everyone, for giving me this opportunity to share my knowledge with you all.
Thank you, ma'am.
Thank you.
Yes, ma'am. Thank you, ma'am. Indu ma'am,
Yes.
is there anything else, ma'am?
Yeah, it's done
It's done.
today. Yes.
Principal ma'am?
Yeah, we can close the session. Thank you.
Yes.
Yeah, thank you. Yeah.
Thank you so much, ma'am.